In this class, we're going to be learning about felonies and misdemeanors, primarily felonies, and primarily the felonies that originated at common law. You will remember from a previous lecture that common law are judge-made laws back in England in the 1700s. We're going to use those original felonies as our basis for our course. At common law, there were only a few felonies. They were murder and rape, manslaughter, robbery, sodomy, larceny, arson, mayhem, and burglary. I've spelled them out in a certain order because if you look at the way they're laid out, you're going to see one of the first acronyms that law students learn. We call these felonies Mr. and Mrs. Lamb crimes. A little corny, but at least it's something that can help you make sense out of it. These were the only felonies at common law. Why were there so few? We probably have 1,100 right now. Why were there so few at common law? There were so few of them because each felony was punishable by death and forfeiture of all the convicted person's properties. So you can imagine that in England, where death was the sentence, they were going to make the felonies few and far between. Any crime not on this list was considered a misdemeanor. So look at the list. What's not on the list that you'd be surprised? You might have thought, oh, I'm surprised, that should have been a felony. Embezzlement's not on the list. Drug crimes aren't on the list. And normally I would joke about that because actually much of the landed gentry back in England were on drugs themselves. Drug crimes were definitely not on the list. Kidnapping is not on the list. Today we have countless more felonies. So how do we tell if something's a felony today? Today, by modern statute, we need to look at the sentence. A felony is going to be judged by its potential punishment. Any crime punishable by more than 1 year in state prison is a felony. When you look at the penal code in your own state, it's not necessarily going to say in any code section, that's a felony. Rather, there will be a sentence provision. That's what's going to tell us that that is a felony. So if it's more than 1 year in prison, it's a felony. If it's less than 1 year in county jail, we call it a misdemeanor. So let's turn to burglary, which was a felony at common law and is a felony modernly. First, we want to go back to what I call dusty England and the 1700s to see what burglary looked like at common law. And then we're going to take that burglary at common law and think about the modern changes and expansions to it. So what's the definition of burglary at common law? At common law, burglary was breaking and entering of the dwelling house of another at night with the intent to commit a felony therein. I want you just to look at that definition. What's it saying to you? Burglary is about breaking in to somebody's home in the middle of the night where that person has the intent to commit a different crime inside. I know that sometimes people think burglary is a theft crime. After all, burglarize a house to steal something, as though taking the something from inside the home was the most important part of this crime. But burglary is much more than that limited situation. I want you to get the visual. When you look at the original definition, that from common law, what you see that burglary is all about an entry that violates the sanctity of the home because it's accompanied by an intent to commit a felony once inside. And it's that vulnerability that a person could feel in their home when someone breaks in to commit a different felony inside the home. Think about that heart-stopping feeling you sometimes have when you hear a strange noise in the night. There you are, asleep in bed, and you hear this noise, or a creak at the door or at the window. That's what we're trying to prevent. That's what we're trying to punish. Somebody who's trying to break in with a different felonious intent. The statistics at the start of the chapter tell us that burglary is one of the most prevalent crimes in the country. It's committed every 14 seconds. Can you imagine that? And it's more scary even that 60% of the people were at home when the burglaries were committed. That's the heart-stopping feeling I was describing. And it's that feeling I want you to think about as we move through the rules, because that feeling is in a sense what shapes the definition of the crime. So let me ask a question. Why not just punish for the crime that takes place inside the house? Why are we punishing for opening the door to steal inside the house? Why are we punishing for lifting the window to go inside to rape? Why not just punish for the act of what happened inside the house? The reason is we think breaking in is worthy of punishment itself. even though in a sense it's its own attempt crime. It's dangerous whether the defendant ever commits the crime inside, whether the defendant ever takes anything, rapes anybody, murders anybody. Just the fact of entering without consent for this felonious purpose is enough.